everybody. How are you today? Super excited to be here. Your school is so cute. I saw some of the comments from the children in shop when I was walking up, and some of them said that they were very excited about getting more sleep. So that was pretty good. I was like, oh, I could identify with that. That's good. That's good stuff. So in your packet, I have a couple of different handouts in there. I don't know if you ever had an opportunity to see the 12-month calendar. It talks about your responsibilities as a board member throughout the year. So it gives you a really good example on where you should be as a board member, each month. The other thing is we're going to talk a little bit about the role of a board member and superintendent when we get to one of the tenets in the Code of Ethics. And then, of course, there's the Code of Ethics in there as well. So I will get started with this. Okay, so just as a disclaimer, this presentation is not meant to give you any type of legal advice. Of course, if you were requiring any legal advice, you'd go through your board president and talk to the board attorney. So you're going to hear a lot tonight about the Ethics Act itself, and the Ethics Act is there to make sure that our conduct as board members is respectful and keeps the confidence of the people. So there are a lot of times where there's situations where board members' conduct comes in and out of, the conduct that's proper for a board member, and it does violate the public trust. So we're going to talk about those parameters throughout the presentation and talk about really where your lane is as a board member. So this is the actual Ethics Commission itself. So there's 9 members in the Ethics Commission. There's 5 non-school officials, 2 school board members, and 2 school administrators. And you can see there that both seats for the school board members is vacant. So if you have even more time to volunteer, you might want to put your name in for the commission. That would be really interesting and super fun, right? So the provisions of the Act, we're going to talk about the mandatory training tonight. We're going to talk about the Code of Ethics, the disclosures that you need to fill out, and the prohibited acts that you have to be mindful of. So this is your mandatory training. So when you're a brand new board member, you have to have that done in the first 90 days. Super important. Just know that any of these trainings, the governance 1 through 4, only the BA can sign you up for these. All the other trainings that we offer for New Jersey school boards, you can sign yourself up for, as long as there's no cost to it. But this you do have to go through the BA. So the BA will set this up for you. So it's that first 90 days, you have to make sure as a new board member that you get that done. Everybody else has till the end of the calendar year, so December 31st. In your second year, you would be doing Governance 2, which is a financial piece, and an updated student achievement piece, which is very, very interesting. In the year 3, you would be doing policy and labor relations, and we are going to do a new program on labor relations. We just hired a new director of labor relations at New Jersey School Board, and that's really going to help you, especially when you're in the negotiations here. And then if you are returning re-elected board member or reappointed, you would take that Governance 4, and that's legal updates. Just know that you can take any of these, in other years if you'd like. It just wouldn't count for that year that you're in. But if you're interested in some of these subject matters, you can take it. And it's live virtual. We have one where we actually teach and take comments. And then there's one that's self-paced, and then it just basically goes through the program and wherever you want. You can come and go, 15 minutes here, 15 minutes there. So, but just please make sure that you have them done by the end of the year, unless you're a first year board member, that's 90 days. And because you will get a little email from the Ethics Commission and say that they're going to possibly be removed if you don't do it. So super important. Those financial disclosures, you have to have that. If you're a brand new board member, have to have that done within the first 30 days of being sworn in. Everybody else should have had that in by April 30th. Super important to get that in. And there is a situation where we're seeing that they're not being filled out properly. So when you go through it, it seems quite redundant, but it's actually asking you a little bit of a nuance different each category. So make sure that you pay attention to that. You can see here where there was a reprimand to a board member who didn't fill out their disclosure properly and didn't include a business organization that they were affiliated with. These are public. Your financial disclosures are public, so any member of the public can see them. And then if they think that you're missing something, they can get in touch with the commission. So make sure that you fill it out properly. So we're going to go through the tenets of the Code of Ethics and talk about what it looks like for each one of them, and things that can go wrong, possible violations. So letter A speaks very specifically to upholding the laws and the rules and regulations of the state itself. So that's basically when you were sworn in, that's what your oath was, that you were going to uphold that. So we just say to ourselves that we make sure that we hold ourselves ethically and within legal parameters as set by the state. Letter B speaks to specifically making sure that when you're making decisions, you're making it for all students. It's very, very important that when you're going through any type of contract negotiation, any type of, looking at curriculums for any reason, things that you're voting on, that you're very mindful of all students, that you're not making decisions just based on your personal relationships, things that are interesting to you, that you kind of lean towards one way or the other, that you're thinking of all the students as a whole and their achievement. So letter B speaks very specifically to that. I love letter C because letter C speaks very directly to your role as a board member. A lot of times board members feel that their role is much bigger than what it really is. But what it really is policymaking, planning, and appraisal. So you just recently did the CSA evaluation. That's your appraisal piece. Planning would be sometimes when you're looking at curriculum committee, the budget, those type of things, planning goals. You just did a strategic plan. That's all about planning. And then policy making, of course, making sure that your policy manual is up to date, that everything is at least 5 years or younger. That's what we say is the best course of action, to make sure that your manual has everything up to date 5 years or younger. If there was a policy that is still working for you, but it's older than 5 years, that's fine. Just read it at a public meeting, timestamp that, and then you can have it exactly the way it is. But that is our recommendation. Speaking about letter C, I did put in the top of your packet here roles of a board member versus roles of a superintendent. We have a very simple way of thinking about what your role is as a board member. Is the board is the what and the superintendent is the how. So when board members call me, and just know that you can call me 7 days a week if you have any questions about your board service, but when they call me, they'll say to me, am I really going outside my lane? And I said, well, are you going into the how? Because if you're going into the how, then the answer would be yes, you're going outside your lane. So we let the superintendent do the action plans, any type of regulations, all that day-to-day activity. As a board member, you're asking that what piece. So how much? Why are we doing what we're doing? What makes this work? Is this advancing student achievement? That's appropriate for a board member, but not that how piece. So if you're going into that lane, just know that that is not your goal as a board member. Letter D speaks to making sure that you're not administering schools. So a lot of times I have board members, they think that, well, I'm going to get onto the board and I'm going to roll up my sleeves and get involved in the day-to-day activity. As a board member, that is not your role. You're just taking a balcony view. So you're sitting up in the balcony, you're looking down at the dancers, and you have that oversight piece, but you're not telling the dancers where to go and what to do. So if you can just envision yourself that you're just in that balcony view and that role of oversight, not rolling up our sleeves and getting involved in the day-to-day. And that's what letter D speaks to. Letter E is making sure that you're not making any personal promises or taking any type of private action that would compromise the board. So with letter E, we think about sometimes an individual might come up to you and say, I'm really frustrated with X, Y, and Z. You have no individual authority as a board member. Your only authority is when you're sitting at this board table and as a team. So please know that you cannot make any personal promises or take any private actions because you don't have that type of authority. And so letter E speaks to that. Letter F is making sure, and we're seeing unfortunately a lot of this, is special interest groups or partisan groups, that you're not surrendering your independent judgment. So sometimes we see this when a board member goes from campaign mode into board membership. They are so used to that campaign mode, and they're so used to, speaking to those groups that are supporting them. When they come on to being a board member, they don't realize, you really can't do that anymore. You have to work together as a team and think about all students. So letter F speaks very specifically to that. We're seeing quite a bit of violations with this. Letter G speaks to confidentiality, and sometimes board members think, anything in executive is the only thing that should be kept confidential. And that's not necessarily true. Of course, anything that is in executive, you should never speak to anybody else. That stays within the board. But sometimes at committee level, there is confidential information that you're speaking of, just information that's not ready for public consumption. And sometimes you have to be mindful of that as a board member too, that in committees, that confidentiality piece is important. You're going to roll out something and you're talking about rolling that out, but the community's not ready for that yet because everything hasn't been solidified. You have to be mindful that that is also confidential. So take note to that. And then letter H, that you are going to appoint the best qualified personnel after the superintendent recommends. So we are not, when you look at this little chart that I gave you about the what and the how of your roles, the how would be a recommendation. So the board will never be able to recommend somebody for a position. That comes only from the superintendent. Once the superintendent recommends somebody, then you go ahead and vote. So just know that you can't say, I think Sally Sue would be a great administrator. That is not the role of the board member. That's that how piece. And letter I, we see some violations there where you're going to make sure that you support and protect the personnel, like our staff members. We saw a violation just recently of letter I where a board member thought it was a great idea to write a blog. And you certainly can do that. You have freedom of speech, the First Amendment. But the problem was that he had all the right disclaimers and everything like that, but he spoke poorly of a staff member. So that was a violation of letter I. So please make sure that, with social media and all those things that go on, if somebody is speaking about a staff member, please, don't join it. It's very important that we uphold letter I. And then letter J. So letter J, most of the time, happens when we are in the grocery store. So you're in the grocery store, minding your own business, a community member comes up to you and says, I'm really aggravated about X, Y, and Z. And you are supposed to be a barometer for the community. However, you're not there to fix the issues or the solution to the problem. So what you're supposed to do is just say, here's the lowest level of chain of command. How did it go when you spoke to the building principal? Or how did it go when you spoke to the teacher? You direct them to the lowest level of chain of command. And then you also let the superintendent know that somebody came in and spoke to you about a certain situation. So those are the tenets of the Code of Ethics. So then we'll move on to ethics complaints. So anyone can file an ethics complaint, unfortunately, against a board member. They do have a 180-day window. They have to make sure that they write the section of the act. And where we see sometimes where they're not founded is because they can't give factual evidence. They do have to give all factual evidence to the incident. We're seeing an uptick with board members putting violations against board members. So you see there in red where there's a $500 fine for frivolous filing. It's mostly because board members are going ahead and putting in violations against, complaints against other board members. So we ask you all to please don't trouble the Ethics Commission with disagreements. Try to settle it within your board itself. These are the penalties if you are found in violation of the Code of Ethics. So you would have the reprimand. That would be basically a letter saying that you were found in violation. And it's basically a slap on the wrist saying, please don't do that again. Then it gets a little bit more serious to a censure. That is read at a public meeting and stays on the website for 30 days, and it's adopted as a resolution. Then there's a suspension, like we spoke about with that gentleman that thought it was a good idea to do that blog. He was suspended for 60 days. So it's usually between 30 and 60 days for that. And then there's a removal. We don't see these often, but we are seeing an uptick because board members are not doing their mandatory training. So just be mindful of that. So advice of counsel defense, we're seeing an uptick with that. And the reason being is that a lot of board members said, well, I did what I did because the board attorney said that it was okay to do. And that's fine, you can utilize that, but it does have to have all 4 of those factors within that advice of counsel defense. So you have to make sure that you had the president go ahead and say, this is the conduct that a board member is going to take. It has to be ahead of time, and you have to disclose everything about it. And then when you do get advice from the board attorney, you have to prove that you followed it to the letter. If you don't have that, then you will not be able to use the advice of counsel to get out of that violation. So here's some of the ethics cases, and I did put them into your electronic copy. And we don't need to read through all of them, but I do just want to highlight a couple of them. That one, the lower one, talks about a board member using their email for personal matters. So please make sure that when you use your board email, it's only for board business. He was attending a CPAC meeting as a parent and utilized his board email. Remember when we talked about the act, we talked about justifiable impression, that you're not violating anything in the act itself, and that gave the impression that you weren't being objective, that you were bringing that board service into that forum. So another example of that is I had a board member email the town council with the board email, but it was on a personal matter, so they were kind of using that as a benefit. So please, anything to do with personal matters, do not use your board email. And this other one that I wanted to just point out, a lot of times board members say, you know, I've been a board member for many, many years. Why do I have to listen to this, ethics presentation? And you can see there that middle one, there was a 15-plus year board member who thought it was a really good idea to go to a staff member's home, pick up a letter from that staff member, bring it to the BA, tell the BA, do not give it to the superintendent, and then didn't recuse herself when the matter was being brought up in front of the board. So that was a 60-day suspension, and it shows that even though you're a seasoned board member, sometimes board members go off the rails a little bit. So that's why we put that one in there. So this is a newer guidance, and it's about recusing yourself versus abstention. So back in the day, board members felt that if they were conflicted, they would just abstain. Now the guidance is that you should recuse yourself if you have a legal conflict. So if you have any type of legal conflict, a relative that you couldn't vote for, some type of business matter that you were affiliated with that you couldn't vote on that, you would recuse yourself, not only from the vote, but from the discussion as well. So it's super important to be mindful of that because most boards have on their agenda abstention, yes or no, and then absent. You need to add this recusal piece, and that's for legal conflict. So just know that you shouldn't do that. The reason why you would have to recuse yourself from the discussion as well is because sometimes your discussion might skew the vote because of what you're saying. So you have to recuse yourself not only from the vote, but the discussion. We get a lot of questions about board members asking, do they have to leave the board table? No, not necessarily. You just say that you're going to recuse yourself on that vote. In your packet, I did put definitions of who you're conflicted, if you know a situation. So it kind of goes down to the whole nuance of what a relative looks like. That's in your packet there, and that's that hyperlink on your electronic copy. And then advisory opinions. Know that you can put in for advisory opinion if you have some type of conduct that you think that you want to do, and you just want to see what the commission feels. Would it be a violation? Would it not? You can put in for that. It does take a little bit. They are all on that link there I put into your electronic copy that you can see. The commission just asks that if you please, look to see if there was another opinion that was similar to what you're looking for. And that cute little police officer there is because a lot of times board members say to us, well, it's just an advisory opinion, like it's just an opinion. Like, do we really have to abide by it? And we say this basically like a correlation. If a police officer said that certain actions would get you arrested, you wouldn't test their guidance. So please don't test the guidance of the commission itself. And I put in just the advisories that were released in 2025 in your electronic copy, so you'll have that in your email. And then a benefit, we put that up here because we wanted to make sure that you understood that sometimes a benefit is very direct and it's easy to say, yes, I'm conflicted. But sometimes it's indirect, where you're going to get some personal gain from voting one way or another. So you really need to know that before you go ahead and vote. And you can see there that there was a reprimand for a board member who basically used their seat to get onto a general assembly. So just be mindful that sometimes it could be an indirect type of benefit. So just know that when you're voting or when you're speaking at the board table that you're not utilizing your seat for gain. And these are the prohibited acts that you would recuse yourself from. So if there was any business interest, any type of professional activity that you're conflicted with, anything that would give you any type of financial gain, gift or favor for anybody or your relatives, you would shy away from that privilege. And then here are some prohibited acts that I put in, and we don't have to read through them, but you can see there that there was a time where there was a board member who thought that they could go ahead and speak about something with their child as a board member. That, is of course a benefit, so there was a censure there. And then conflicts of interest. A board member thought that they could go ahead and contact the superintendent and the board president about something that involved their spouse and believed that it was just like a little minor thing, so it was no big deal to do that. And the Ethics Commission felt that it was a violation against B and D, so there was a reprimand handed for that. So we know that we can't hire any relative of a board member. If there is a board member who has a relative that works for the district already, that's fine, but we couldn't hire a relative of a board member or of the CSA. This is a little bit newer guidance about a conflicted board president. So if a board president has a relative that works in the district, they couldn't be on any of the committees that touches that job. So personnel, negotiations, instructional, any kind of finance committee, and they couldn't pick the committee chairs either. So if you are a conflicted board president, then you have to hand that task over to the vice president. And I put in here, I don't know when it's going to be, a negotiation year for you, but I made sure that I put in here whether you can be involved in negotiations and or ratify the contract. I think this is a really good graphic for that. And then if you're supported, and this isn't really very common, but if a board member is supported or endorsed by the union, then you couldn't be involved in negotiations for the first year of your board service. We get a lot of questions on volunteering in schools, and as a board member, yes, you can volunteer in schools, but it's that level of volunteerism. So if you are going to do any type of activity in the schools that you're going to be giving directive to any staff member, then you as a board member could not do that type of volunteerism. You can go on class trips, you can read to the school, to the children, but you cannot give any type of directive. So if you find yourself doing that in any type of activity, you would not be able to do that as a board member, but everything else you should be fine with doing. Just know, though, that you shouldn't be a staple in the school, so you shouldn't be there whenever you choose. You have to let the superintendent know what type of volunteerism you're doing and when you're going to be there. And then also, we ask when you're visiting the school to refrain from anything related to board discussion. So anything at the board table, sometimes if a staff member approaches you about that, please don't discuss that when you're visiting the schools. And then social media has been just really difficult for the Ethics Commission. They're asking that you make sure that if you are going to go on social media, and of course you have the right to do that as a board member, that you make sure that you put this disclaimer exactly. This disclaimer was made by the commission itself. And it's, we just have to be clear, though, that it's not saying that if you put that disclaimer that you won't have a violation against you, because sometimes it's about the content that the board member wrote in their post. So if you're speaking like a board member, remember the Act talks about the justifiable opinion of the public to see that you're not speaking for the full board, that you don't have the authority to do that. If you're speaking in your official capacity, but then still have this disclaimer, the disclaimer is not going to do you any good. So please make sure that you don't speak as a board member, that you're just speaking your personal opinion when you post on social media. And this is some of the social media cases that came about, and there's been quite a few, but you can see there on that lower one where they use the word we, so it gave the justifiable impression of the public that you're speaking for the full board, and you wouldn't have the authority to do that, so that's why there was a reprimand there. And then finally, some of the information that we want you to be mindful of is texting at the table. We're seeing a lot of that. Board members have their phones out at the table. Just know that if you're texting, a member of the community could think that you're texting each other on how to vote, things like that, and they can over the results of your phone records. So please refrain from texting at the table unless you want to have that type of situation. We ask that you refrain from that. Also, if you have a campaign page that you utilize in social media that identifies you as a board member, we ask that you take that down and not post from that, because that gives that impression that you're speaking for the full board. And there has been a case where a board member was administering a social media page. There was a violation there because it was saying that the board member was shutting down some of the comments that the community had about the schools. So if you're administering a social media page, you might want to hand that over to somebody else while you're a board member. And I put some hyperlinks in there for resources for you to, you can look up the Ethics Act and all of the advisories. And they're also in your school board notes that you get every single month. And that's that. Thank you so much for your time and attention. I really appreciate it. Anybody have any questions? No? Okay.
I have a question.
Yeah.
So if Board of Education decided that they wanted to have a Board of Education social media account that they used in, limited circumstances, understanding that anything they put there, they have to be careful with what they put. Is that something that's ever done or recommended, or?
It is not recommended.
Okay.
Has it been done? Yes. Look, if you put public knowledge where it's like, oh, it's going to be a snow day or what have you, but usually the district has their own site that does all of that. What we have seen where board members feel like they really want something on social media about the board work, and that's great. That could either go in a newsletter that you as a superintendent does, I don't know if you do that, or, they can have a little corner of the district website where it just talks about some of the great things that the board is doing. Like, let's say the board decides to get certified and they want to, discuss about how they were certified. Things like that can be, showcased there. But as a board member administering that, it goes against everything that I spoke about. So it's not recommended.
I have a quick question. What if a board member just wanted to post online, like the time and date of the board meeting? Just facts, that's it.
Yeah, anything that's like public knowledge, like I said, like a snow day, that something, a community event is coming up at the school, certainly you can do that because you're still a community member.
Sure.
It's just that you just can't appear to be speaking for the full board.
Makes sense. Thank you.
Yeah, my pleasure. Anybody else?
So then just
Following up on that, your recommendation would be if the board wanted to put information out that they felt they wanted to communicate, that it would be best to have it come from the board but posted through one of the district's either social media site or website or something like that.
Yeah. I mean, is there an example of what the board wants out there?
So, yes, so there's a lot that goes on in social media sometimes. And sometimes it's obviously very difficult when either maybe facts are not accurate or things like that. So if there's an occasion where things are posted that may be factually inaccurate or could even rise to the level of creating, issues with public trust in the school districts, what would be the best way for that information to be shared with the community?
Yeah, that's really not the board member's role. That would be the superintendent.
So the superintendent would do that.
So let's say that the board members are coming to you and saying, I'm hearing all through our community all this information. We're really frustrated. We're sitting here doing this work and it's not accurate. Then sometimes a superintendent might choose to put out some type of public notice saying that. Sometimes at a board meeting, you do have the president report. The board president can have a statement as long as you go ahead and make sure that it goes through the attorney just to okay the statement. You might want to do something like that. You can do something like that for that avenue. But misinformation is really important that it comes from a district level, so from the superintendent. Yeah, my pleasure. Anybody else? No? All right, well, thank you so much. I appreciate your time.